The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Hi, this is Heather Jones, a family law attorney with O'Flaherty Law, and today we're going to do a how-to video for filling out a notice of motion and motion to change either legal custody, physical placement, child support, maintenance, or an arrears payment, or there's also an option in this form for another motion on the court. We are using Family Law Form FA-4170V. It can be found on the Wisconsin Circuit Court website under Family. And this video is for educational purposes only. It is not legal advice. If you are having trouble with your case and need help, you should consult with an experienced family law attorney in Wisconsin. So I have the form open here on the screen, and you can see at the top that it actually has a space at the top left-hand side for petitioner and respondent or joint petitioners. So this is kind of a catch-all form that you can use a few different ways. So it's kind of a big form and it can look a little complex. This form can be used for a joint motion, which is why they have the option to do joint petitioners, or just as a petitioner and respondent. The petitioner is the person who is asking the court for relief, and the respondent is the person who is not filing this. So looking at the top of the page, there are instructions running down the left-hand side of the page, but sometimes they're not as complete as they can be, and we want you to be able to fill out your notice of motion and motion to change item X correctly the first time without having to do an amended motion. So you'll want to put in the name of the county where your original divorce or custody battle was in. It's not necessarily your county of residence for this form. If you can't remember, you can always pull up your case on the Wisconsin Circuit Court Access Program and get the case number and the county it was filed in so that you have the correct information. Since this is kind of a catch-all form, they have a lot of options you can choose from. So it would be in regard to the marriage of, if you got a divorce, or the paternity of, if you had a child outside of marriage. You would put your name and contact information if you're just the petitioner or if you're a joint petitioner. Just make sure that's filled out completely. The same goes for the respondent. If you don't have their current mailing address, that's okay. And if it's a joint petitioner, they'll have it. Moving to the right of the page, you'll see notice of motion and motion to change. So a motion is just when you're asking the court for something. It's not exactly like a petition. A petition opens a legal case. A motion happens within a legal case. It's called motion practice. And you have to notice the motion, and then you have to have the separate motion. Now here it's all one form, and that's fine, but you do have to have that notice in there just so that the other party, if it's not a joint motion, will have appropriate notice that you are asking the court for changes to an existing order. You see here that there are a lot of options here. There's legal custody, physical placement, child support, maintenance, also sometimes called spousal support, an arrears payment, that could be on child support or maintenance, and other, if you've got some sort of unusual issue that you need the court to take care of for you. If you have a case number and you're filing in an existing case, you can put it here. If you don't have a case number, tell the clerk of courts when you file and they will get you one. So here, because the state of Wisconsin Child Support Agency does involve themselves in child support cases, especially if it's an issue of non-payment or the parties were never married and the child support agency had to go in and get an order from the court, they could be a party to the action. Just be clear whether or not they're a party to the action. So if this is not a joint petition, you need to fill out completely the notice of motion. Now, this is for the court. If you had an attorney, the attorney could call and get a hearing date, but since if you're filling this out on your own, you're probably unrepresented, the court will give you a hearing date on the motion for your motion hearing. So the notice of motion will go to the respondent. The court will give you a hearing date. If they don't give it to you right when you file, they'll say, or as soon as the matter may be heard. So that information is for them, but there's going to be a location, who it's going to be, what judge it's going to be in front of, the date, the time. Make sure you put that on your calendar. Don't miss it. Here's where you say, I will be asking the court to change the existing order in this case, as indicated below. And if the respondent objects to the motion, they need to appear and say so. Otherwise, the court may proceed without them and grant the request. So it's important that if you're filing this as a petitioner, that you properly notice the other side so that if they don't show up, it's on them. You may contact the Office of the Family Court Commissioner for written information on modifying and enforcing court orders or judgments. That's always an option. If you have trouble locating your family court commissioner, you can always just call Clerk of Courts, ideally with the case number and the names, and find out who you're supposed to talk to. So that's the notice of motion, and it's imperative that it be complete and properly served. Moving on to the motion part of the form. So like we said before, this is sort of a very broad form that you can use for different family law issues. So you need to know exactly what you want before you ask for it so that you don't waste a bunch of time sort of going in circles, not really knowing how to articulate what you need out of this document. So we'll start with a physical placement. So if it's a motion to modify physical placement, and it can be more than one, you can be asking to modify physical placement and as a consequence support because there's going to be a big change. So modifying physical placement, you need to identify who's in the order, which children, who's the primary physical placement, who you want to change it to, and you should really just have your existing order out and go off of your existing order. If the other parent has primary physical placement and you want to switch it and have you take over primary placement, or you can go from shared placement to primary placement, or you can go from primary placement to shared placement. You can also, moving on, go from current shared placement schedule to a new shared placement schedule. And if you picked 1 or 4 up above, then you would need to put in what new schedule and placement you want for the children. And 2 lines really isn't enough, so you can always just click See Attached and write out your proposed new placement schedule for the children on a separate sheet of paper and just title it Proposed Placement Schedule. And make sure it's very clear and easy to understand. You might want to number the pages so that when we're going over it in court, it's easy for everyone to locate the page you're talking about. Moving on to number 5, if either parent is receiving less than 25% placement with the minor child or children, the specific reasons more placement with that parent is not in the children's best interest is as follows. And again, this one line probably isn't going to be enough. You're going to need to do it on a separate sheet of paper. Do not modify the form. And always remember what the standard in Wisconsin is for placement of the children. What is in the child's best interest? It's the best interest standard. It is applied to everyone who comes through the family court. The court wants to make sure that the children's best interest are being represented. It's not really about what makes the parents that happy. It's what's best for the children. So always keep that in mind when you are writing your reasoning for changing placement. Number 6 is not uncommon at all. When there are two people who have a child or children together, sometimes either before or after the breakup, one of the parents starts doing things that the other parent believes is unwholesome or not in the children's best interest during visitation. That is why you have the option here to ask for supervised visitation if you want it. And that can take a lot of different forms. That could be finding a neutral third party who will be present in the home of the parent who has supervised visitation. That could mean even just the supervised visitation parent meeting at a neutral location, no longer having the children in their home. Say, for example, and this is a common one, the parent with supervised visitation is having trouble with drugs or alcohol, or they're running around with some unsavory people that you don't want your kids around. You could go in and ask for supervised visitation and make sure that they are not spending a lot of time over at parent X's house or even doing overnights there because it's turned into a party house. Number 7 is just that catch-all that we talked about in the title of the document, other. If there's some kind of issue going on with visitation or custody that is creating a problem for the children that is not in the children's best interest, here's where you would click that option, bring it up with the court. One line is probably not enough, so you're going to need to use that See Attached option and attach it to your form. Now, this isn't a numbered paragraph, but it's always a great deal of interest to the court. You always have the option, if you are struggling with the other parent, trying to co-parent, trying to stick to the court order about custody, placement, visitation, support, there is always the possibility that you can just go to mediation and try and work it out with each other. The court likes this form of alternative dispute resolution because people tend to stick better to options or solutions that they have created with each other as opposed to what the court has told them to do. And it also kind of frees up the court schedule a little bit, which I'm sure you realize is probably very full with parents fighting. So it's my opinion that it's always great to at least suggest attending mediation about this. And if the other parent says no, well then fine, but at least you've suggested it, and if the commissioner asks you about it at the motion hearing, you can say, I brought it up, the other side just didn't want to do it. So then we have option B, the option to talk about legal custody. So depending on what your existing order states, you may have sole and someone's trying to change it to joint, or you may have joint and you want to change it to sole. The legal custody is what gives you the power to make decisions for the children that could affect them for the rest of their lives. You know, where they go to school, medical decisions, religious decisions. If you have sole legal custody, you really don't have to consult very much with the other parent at all. Joint, you do. So if you're wanting to change legal custody, here's where you would describe that. And if you have something other than joint or sole that you want to try, you need to explain it to the court on a separate document, clicking See Attached, and tell the court why the decision-making power for the children needs to be changed. So option C is child support. And child support should be laid out in an order for you. You should have something in writing telling you what is being paid every month and why. So you would lay out what you're currently getting per child and whether or not it includes a deviation for health insurance. And a deviation for health insurance is just that. It's a deviation from whatever the formula states you should be getting, and it can go up or down, depending on which parent is paying for health insurance for the child or children. And that should be included in your existing order. And if not, maybe you could call the child support agency and check in on, I can't imagine you not knowing this, but check in on what you're supposed to be getting and if there's a deviation at all. You're going to need all that information to give to the court before you ask for a change in any child support. Because here in paragraph number 2, you give the new amount to be paid by, probably in this case, the respondent. And you say that it's based on state child support standards determined by the court, a new set amount of X amount per child, held open. And you request that whether or not you want a deviation for health insurance. Let's say a scenario here would be the other parent is supposed to be paying health insurance and they are not. You have put the children on your policy. So you might want to ask that there's a deviation in the child support upward because they're supposed to be paying health insurance and they're not. You're covering everything. So that would be one scenario where you could conceivably use this option within the motion form. But again, like I said, just have your existing order out in front of you when you're filling this out. Make sure you get every number correct and you can back it up with a court order. So maintenance is option D, otherwise known as spousal support. And you would list what you're currently getting, and you would list why you want it to be adjusted based on current income. Then you would list what you want and when you want it to start. And this seems very simple, but I would not walk into the motion hearing without some proof showing that you were entitled to a different number. And you'll see even at the bottom, I will be able to provide documentation to the court that supports my request. So that applies to everything you ask for in this motion. I mean, the motion just gets the process started. You can't walk in and just say, well, I heard that my ex has a new job and he's making double what he made when the court awarded me maintenance. So the court's going to need to award me maintenance in a figure reflective of his new doubled income. You've got to have some proof. Option E is an arrears payment. So if somebody owes back maintenance or back child support, usually the state will take care of back child support. But if they're in arrears on their maintenance, you need to tell the court how much, and you can do an amount beginning on X to be determined by the court, or you can ask for a new set amount of X per month, usually beginning on this date. Then at the top of page 2 or 3, you'll see a notice. If you're fighting about money, the court wants you to bring a fully completed, dated, and signed financial disclosure statement to the court. We could go over this in another how-to video, but the financial disclosure statement is basically just each party listing what their bills are every month and what their income is every month, so the court is not trying to operate and make decisions in a vacuum. If you're asking for an increase in maintenance, or if you're paying maintenance and you believe that maintenance should be decreased, you need to bring in documents that the court can look at and use to ascertain whether or not your requests are even viable. The court can't just have two people come in and one's screaming that the maintenance is in arrears and the other is saying, look, I've been paying, he's lying, and make a decision based on that. A court needs documentation to evaluate whether or not the court can even do anything for you. If the court has no evidence to kind of hang its hat on, the court is unlikely to make a decision in your matter that day, the court will probably send you out to complete the documentation that you're supposed to have completed, and then you're going to have to wait another month to get a court date to come back in and get a decision made. So just have the paperwork ready. Option F says once again, it's the catch-all. Are there any other changes regarding arrears, maintenance, child support, anything else that you want the court to do for you, but that's not listed in one of the above options? And then, of course, usually it's more than one line, so you have the option to click See Attached, put it on a separate sheet of paper, label and number it as completely as possible for ease of access, and attach it to your form. You should have, as I've been saying throughout this video, a copy of the court order you want changed handy. That way you can just put the date of when the court order was entered. You should have the court order with you when you go to your motion hearing. And if you want, you could probably attach a copy to the motion, but otherwise the court should be able to know what you're talking about from CCAP, but there could be more than one order in your case. So make sure you put the correct order and the correct date that you are asking to be modified. So option 3 here really goes more to the standard for making changes in things like placement, child support, and maintenance. And the standard is a substantial change in circumstances that have occurred since the entry of the prior court order in this case. So here are your options, and you don't have to just pick one. You can pick several, or none if they don't fit. So the options are: a child who was living with the other parent is now living with me. A child is no longer eligible for support because they've reached 18, or they're over 18 but under 19, and they're no longer pursuing a course of education leading to a high school diploma or its equivalent. One of the parties has or will be moving to a different residence. The parties are no longer living together. There is not a placement schedule and the parties cannot agree. Employment or work shift of party has changed, or both parties has changed. Change in income or wages of one or both parties. The availability or cost of health insurance has changed. Remember, we talked earlier in the video about deviation. The party to whom maintenance is owed has remarried. Always a favorite. And then just J, other, if there's nothing up here that fits your situation. Then you need to explain why whichever options you listed up here, checked off, why it's a substantial change in circumstances. And it's probably going to take you more than 2 lines. And that's why you would do it on a separate sheet of paper and hit the See Attached and just attach your explanation to the form. This is your chance to lay everything out for the court and explain why you are asking for the changes above and beyond just giving one little reason. This is your chance to create a narrative, to create a context, to tell your side of the story. So you're probably going to want to use more than 2 lines. So in this court form too, because they're setting a hearing, if you require reasonable accommodations to participate due to a disability, the local county that you're filing in will have this information on their clerk of court's website, and if they don't, you can call the clerk of courts and get the number that they want you to call for special accommodations. But that does not provide transportation. That's just, say you have a hearing problem, they would try to accommodate you in the courtroom. Say you need an interpreter of some type, this is where you would start the process to ask for it, or if the other side needs it. So that phone number should be on the clerk of court's website, and if it's not, call the clerk of courts and get the number they want you to call. So because this is a motion, it's not a sworn statement, it's not an affidavit, and it's not a petition with a bunch of vital information in it. So you just sign. And signature, print, address, email, telephone, date. And then because attorneys do use this form, they have a spot for the state bar number. So here's something you really need to pay attention to. Like I said earlier in the video, it's really important that notice and service of this motion are proper. Because if you don't give the other side a reasonable opportunity to receive notice and even thoughtfully respond to your motion, because they have a right to, it'll just get kicked out and you'll have to start over. So a copy of this notice of motion in motion must be served upon all other parties. And remember, that could also be the State of Wisconsin Child Support Agency, at least 5 business days before the date of the hearing. If service is by mail, and it can be, it must be mailed at least 8 business days before the date of the hearing. And there is a packet form on service also available at wisconsincourts.gov. And maybe we'll have to do a how-to video on that, because service is very important when you're filing things in the court and asking for changes to court orders and hearing dates. Everybody has their right to due process, and that includes proper service. So again, a warning. We've talked a lot about preparing attachments and attaching them to the form. And that is because this form cannot be modified. You cannot add space. You cannot add lines, so it's all just one document. It needs to be supplemented with additional pages. And the reason why is that this form has been prepared to satisfy the requirements of the Wisconsin state e-filing system. So don't change the margins, don't change the font, don't make any changes to the form. Just if you can't fit something in the lines that they offer, put it on a separate page, label it as an attachment. Furthermore, every top left-hand corner, you're going to want to put your names there. Whether you're joint petitioners or petitioner and respondent, include your names on the top left-hand corner of every sheet on this form. And that is Form FA-4170V, your notice of motion and motion to change many different things that can come up in family court. I want to thank you very much for watching. To learn more about post-judgment motions or family law in Wisconsin, you can visit our page. It's linked below. And be sure to leave any questions you have in the comments section and subscribe for more legal content daily.
Hi again, this is Kevin O'Flaherty from O'Flaherty Law. I hope you enjoyed the video and podcast. If you did, I'd love it if you'd subscribe to our channel. If you need legal help in this or any other area of law, please don't hesitate to reach out to schedule a consultation. Most consultations are free and can be conducted remotely if you'd like. You can email us, book online, or call us at 414-253-2080. That's 414-253-2080. We have many locations for your convenience and we serve all of Wisconsin. Thanks again for watching.